In 2016, the DOJ announced its intention to begin treating restrictive hiring practices as criminal conspiracies, in addition to continuing its antitrust enforcement efforts. The first indictments from that campaign were handed down in 2020, and the first of those trials occurred earlier this year. The first two cases to return verdicts resulted in losses for the government. In our webinar last year, we discussed the indictment handed down in U.S. versus DaVita, in which the government alleged criminal conspiracy based on a no-poach agreement. That case went to trial in April of this year. The government alleged DaVita conspired with other healthcare companies not to solicit employees of each other. Although the court recognized that the arrangement could be a per se violation due to its horizontal structure, the court indicated that not every non-solicitation agreement or even no hire agreement would be treated as per se illegal. In fact, the court declined to instruct the jury to that effect. Ultimately, the government was unable to meet its burden of proof that DaVita intended to allocate the market as charged, and the jury returned a not guilty verdict. In U.S. versus Jindal, this is a fee-fixing case brought under the Sherman Act, in which the government alleged that a therapist staffing company engaged in price fixing by conspiring with competitors to keep wages low. The district court found that even though the facts of this case do not present those typical of price fixing agreements, the definition of horizontal price fixing agreements nevertheless cuts broadly. And the court reasons that any, quote, naked agreement among competitors, whether sellers or buyers, that fixes components that affect price meets the definition of a horizontal price fixing agreement, relying on Supreme Court precedent. Applying this analysis, the court determined that the Sherman Act's prohibition against price fixing applies to buyers of services or employers in the labor market and rates paid to employees. Nonetheless, the jury acquitted on all counts except for an obstruction charge. In U.S. versus Surgical Care Affiliates, which remains pending, defendants are attempting to capitalize on these rulings, arguing that its own no-poach agreements are not per se illegal. We are also waiting on the outcome of U.S. versus He, which is another wage-fixing case brought in the same wave of indictments, in which the government accused a healthcare staffing company and its former manager of scheming to suppress wages for school nurses. That case is set for trial next spring in Nevada. So what does this mean going forward? Healthcare companies can expect more scrutiny of deals and continued and expanded criminal charges of illegal wage fixing and no-poach conspiracies, as well as criminal antitrust charges in monopoly cases, which to date has largely been limited to civil enforcement efforts. We can also anticipate an increase in state legislation regarding non-compete laws, as well as possibly requiring review of healthcare mergers and transactions. That is why we recommend that all of you review your restrictive covenants and antitrust compliance programs to address these issues and be prepared.